Hello everyone, this is Anukriti Jain, a second year law student pursuing BLLB honors from Institute of Law, Nirma University. Also, I am currently interning at a law firm, Sejpal Associates, Ahmedabad. In this video, I will be doing the case analysis of a landmark judgment, the Animal Welfare Board of India versus A. Nagaraja and others. Before moving into the case, first let's discuss about the Animal Welfare Board of India. This board is a statutory advisory body to the Government of India. It was established in the year 1962 under the Section 4 of the Prevention of Cruelty to Animals Act 1960. This board was established by a well-known humanitarian, Srimati Rukmani Devi. Initially, it was within the jurisdiction of the Ministry of Food and Agriculture, but now it's under the Ministry of Fisheries, Animal Husbandry and Dairying. This board was established to ensure that the animal welfare laws in the country are diligently followed, that it provides grants to the animal welfare organization, and also it advises the Government of India on animal welfare issues. It has been in the country for the last 50 years. The headquarters of the Animal Welfare Board of India has been shifted from Chennai to Haryana's. Now let's move on to the main contention, the main issue of this case, which revolves around something called Jallikattu. Jallikattu is a sport conducted as a part of Mattu Pongal. Mattu Pongal is the third day of a 4-day long festival of Pongal. Jallikattu is also known through various other names such as Manju Virattu. Now let's get into the literal meaning of Jallikattu. It is evolved from the word Salli, which means coins, and Kattu, which means tie. So basically, a bundle of coins is tied to the bull's horn, and whosoever hold on to the hump of the bull and tames the bull for the longest time wins these coins. Jallikattu is a symbol of a cultural pride for the state, as it is considered as an ancient sport to embrace the bull. When the bull wins during the game, they are used for further breeding and will also be the most expensive cattle in the market. So this is all about Jallikattu. Now let's get into the case. The date of the judgment was 7th May 2014 and the bench, which comprises of Justice K.S. Radhakrishnan and Justice Pinaki Chandra Ghosh. This was a widely celebrated judgment as it brought the rights of the animal under the ambit of right to life and liberty that is enshrined in Article 21 of the Indian Constitution. The present case is concerned with two very important issues, as on the one side there are rights of the animals, the law of the nation. On the other side there is culture, tradition and religion of people of Tamil Nadu and Maharashtra. The case was analyzed with reference to two acts, that is the Prevention of Cruelty to Animals Act 1960 and along with that the Tamil Nadu Regulation of Jallikattu Act 2009. Now let's get into the issues. The issues concerned in this case are whether the events that are being conducted in the states of Tamil Nadu and Maharashtra are in violation of certain sections of the PCA Act. Second issue, whether the provision of TNRJ Act is in conflict to the PCA Act, which is considered as a central act. Now let's move on to the important provisions and the provisions in conflict. Section 3. It talks about the duties of person having charge of animals. Basically, it shall be the duty of every person having the care or charge of any animal. He should take all reasonable measures to ensure the well-being of such animal and he should prevent the infliction of any unnecessary pain to that animal. Section 11 talks about two things, treating animals cruelly and second, using animals solely with the view to provide entertainment. If any person beats, kicks, overrides, overdrives and torture any kind of animal will come under section 11 clause A, and a person which uses animals solely for providing entertainment by sale of tickets, will come under Section 11, Clause M. Section 21 talks about two things. It defines the word exhibit and the word train. Exhibit means to showcase the animal for the purpose of any entertainment. The word train means training the animal for the purpose of such exhibition. Section 22 talks about such restriction on exhibition and training of performing animals. Performing animals are nothing but animals which are used for the purpose of any entertainment. Last but not the least, Section 28 is an exception wherein it will not be considered an offense to kill or sacrifice any animal in the name of religion of any community. The judgment was in the favor of the Animal Welfare Board of India, as the use of bulls in exhibition such as Jallikattu, bullock cart race, etc. was banned. The bulls and other animals were used as a part of festivities taking place in the states of Tamil Nadu and Maharashtra. They were physically and mentally torturing them just for the sake of human pleasure and enjoyment. Therefore, the court directed the government and the board to take steps to prevent such infliction of unnecessary pain and suffering on animals, saying that all living creatures, including animals, have inherent dignity and a right to live peacefully and the right to protect their well-being. For the purpose of the analysis of the judgment, we'll look into four different perspectives. First being the cruelty to animals. The court noted that Section 11 of the PCA Act deals with the cruelty to animals. Section 11 is a very useful provision that is criminal in nature and was designed for the welfare and the protection of animals. Because it is punitive in nature, it puts responsibility on all humans, especially those in charge, to take care of the animals. According to various investigations by the board, it was resulted that the bulls are subjected to great cruelty and suffering, and this is in the violation of Section 11, Clause 1 of the PCA legislation. Now, second, non-essential activities. The court stated that there are several non-essential human activities that can be avoided, such as bullock cart races and Jallikattu, which inflict great deal of cruelty to animals. Despite the fact that it can be avoided, but they are ignored solely for the purpose of human pleasure and entertainment. The court also determined that excitement, presentation, or entertainment do not belong to the under-exempted classes in Section 11, Clause 3 of the PCA Act. Therefore, there was no need for them. The board also considered that these events harm the animals not only physically but also mentally, which includes fear and pain. And as a result, both anxiety and terror play a key role in animal suffering. Now looking into the third perspective, that is the inclusion of animal in the ambit of Article 21. Every creature has a right to life and security. While protecting human rights, Article 21 of the Indian Constitution also protects life. The term life has a broader perspective. It only keeps in mind not only the life of humans but also the life of animals, who have every right to live with dignity. Therefore, they fall in the ambit of Article 21. Various reports indicate that bulls are exposed to cruelty not only physically but also mentally, as explained above. They are inflicted with so much pain, they suffer, they traumatize, they injure, and sometimes even result in death. Therefore, it was very necessary to protect their life and bring this in the ambit of Article 21. Even after considering all these perspectives, the question arises whether the decision was right or not. There have been various cases of death and threat to public safety, so in the eyes of law, the decision was right. Even though the bulls are not slain, they endure great amount of stress. They are being followed and jumped upon by the crowds of individuals. Supporters of the act argue that basic regulation in question, dealing primarily with event planning, erecting blockades, and limiting the number of participants, go unenforced, and this is what resulting in threat to public spaces. Furthermore, it is against the Prevention of Cruelty to Animals Act 1960. However, the inverse of the situation must also be addressed. The PCA Act is one of the acts passed after the independence and have frontier perspective. Bulls and other performing animals, like those in carnivals, are presumed to be performing animals. But in this regard, the coordinators contested that the tickets were not sold. So these animals cannot be considered as performing animals. The court fails to take this perspective into consideration. Also, the Supreme Court, instead of banning it completely, could have imposed strict rules which ensures its safe conduct. Nevertheless, the decision was right, keeping in mind the suffering of the animals, and it was high time to protect the animals from such cruelty. These pictures clearly show the cruelty and the pain which is being inflicted on the animals. Therefore, the Supreme Court was right in its decision to prevent such activities and prevent the suffering of these animals. Thank you.